Good evening, friends. When you have Professor Nilima Bhadhade and also an author on the platform, you are always sure that there will be a different topic and it will also be an insightful. We have already done 3 sessions on the perspective of contract, and then we did one on the moots. How do we do the basics of moots? There was one on the specific relief act, and today also, when I connected Ma'am Nilima Bhadhade, transpired that she has authored a book, Heirship Certificates, under the Bombay Regulations VIII of 1827. So it's a very niche topic, but be that as it may, Heirship Certificates has common trappings everywhere. And once, even otherwise, there's a book written by Professor Nilima. There couldn't be a better way to have an insights or a peep into that book to the PPTs and from her knowledge. We are obliged that ma'am has always been encouraging us and taking different topics. Over to you, ma'am.
Yeah. A very good evening to everyone. And it's a pleasure for me to be at Beyond Law CLC. The other sessions on Beyond Law CLC, there are many experts who deal with procedural aspects of practice. And that is why I follow many of those lectures and also take down notes, especially when judges talk about laws of procedure and laws of evidence. Before I proceed, Vikasji, please confirm whether my voice is fine. It can be heard.
It's perfect.
Yes, very good. So namaste to all of you. When I had an occasion to think about heirship certificates for the purpose of writing a book, the offer came from the other co-authors whom I will list later. Well, I didn't know much about it. In fact, if an advocate wanted to file an application for heirship certificates in the civil courts in Pune, there was nothing to guide him. He will have to look for an advocate who has filed such application, or he has to refer to the officers in the court and ask them how it is done. This is a very peculiar law made by Elphinstone, when he was the Governor General of Bombay. Its purpose I will come to later. But the thing is that you ask some people, what do I do if I want representation for a deceased person's estate? And so many lawyers would say, Nilima, there is some very old act, very old law, British period law, under which it is given, what you inquire about. My point is that very few people knew about it. And that is the reason why learning about heirship certificates for the purpose of writing the book gave tremendous insights about how the law has developed. So let us proceed. I start with the fundamentals first, the background. If a person X dies and then he has relatives, these relatives, they are going to succeed to the estate of that person. So there is a relationship and then an entitlement which comes under the law. If he has died without making a will, then who will be these heirs is decided by the personal law of the deceased. Very often the wife, children, and in some cases mother and father are the heirs. And the word heir has got a very distinct meaning. Heir means that he is related to the deceased, and then by law, because he is so related, subject to that law, he gets a share in the estate of the deceased. So that person is an heir. Heir is not just a relative. We keep that in mind. And if he has made a will, then that person will succeed as is stated in the will. So our next question is that when does the title vest in them? So let me go to the next slide. When do they become the owners after the death of X? So if it is intestate, heirs, and if he has made a will, then the legatees. When do they own it? When can they say this is ours? And now, therefore, we can deal with it, we can sell it away, we can enjoy it, we can use it, and so on. So when does it vest in them? When do they acquire title and therefore the ownership to that property? Okay. So if they are heirs, one thing we remember that the law does not tolerate any gap in ownership. So the moment X has died, somebody naturally becomes its owner. Now, if he has died intestate, then all the heirs become owners according to law, and they all have undivided share in all his properties. And if he has made a will, then we ask the next question, has he appointed an executor? If he has appointed an executor, then we have two kinds of ownerships. The law says, and I come to my second point here, 211 of the Indian Succession Act, that property vests in the executor, but that is only for the purposes of representation. So I will later on come to what is meant by representation. However, the beneficial interest means who is the actual owner of it, who will enjoy it. It is in the legatee. So the legatee has a vested interest immediately on death, but who can represent the estate is the executor. And in order to complete the title of that legatee, remember, representation is with one person and beneficial interest is with other. How will he become fully capable of handling it? That is only with the consent of the executor, and that is section 332. And I will request all of you that these three sections represent a fundamental principle of acquiring title upon the death of a person if there is a will and an executor. And you must read these and master these in detail. I will not be coming back to wills again because heirship does not require a will. So our question was, when do they become owners? When does the title vest in them? And because it vests in them, they enjoy some powers. What are those powers? As an owner, they can use them. Okay. But let us suppose that my other heir has got the bungalow in his hands and I am the other one heir. Then I will have to file a suit to assert my right to say I have a share in the property. Then as an owner, they will want to transfer it. If somebody has only half share, he will want to transfer that share. He will want to make a will of that share. When can he exercise that power? They will also be required to collect, for example, amounts which were owing to the deceased, the investments, they are to be collected. And then they will divide it among themselves. So when will they be able to do that? They are able to do that only when title vests. But there is this issue in 332 of the ISA which says, to complete the title of the legatee, the executor comes into picture. So now let us proceed ahead. What is meant by administration? Because what we are dealing with is how is the estate to be administered. Administration involves collection. So all the assets are to be collected. They are to be managed because distribution will take time. So rent is to be collected. Repairs may be required to be done to properties. Investments are to be made or they are to be realized. So you have to manage that property as if that person is alive, he would have managed it, right? And having managed it and collected it, then it is to be distributed based on the law of succession. So it will be distributed to the legatees, or it will be distributed among the heirs. So how many actions are involved? The first is identify the assets. So you send notices to people to say, well, you owed money to my father, please confirm, and so on. Remember, if there's an executor, the executor does all that. Then to make inventories, that is the lists of those properties. Then collect the assets. So the amounts which are owing are to be collected. Investments are to be collected. So collecting those assets. Then taking custody means keeping them under the control of this person. Then to manage them, right? So for example, if there are shares on which calls are yet to be made, then calls are to be paid. Rent is to be collected, rent is to be paid. This will be management. Then to sell and transfer them, to realize the investments, to change the investments, to sell immovable property, to give immovable property on lease, etc. Then identifying the debts, because this person who is dead owes money to others, that is his debt, that is to be paid off. And he may have liabilities like tax liabilities, or he may have liability under contract, or liability under tort, or pending litigation. Those are to be paid off. So identify them and pay them off. After that, pay if there is a will, satisfy the legacies. And our Indian Succession Act gives in great detail which legacies will come first and which legacies will come later. Go through that. So those are paid off, and the rest of it is to be distributed. And if there's a will, it will be distributed according to the will. If there is no will, then the distribution is to be done according to the shares of the parties. So this is administration. And after the person is dead, somebody has to take it upon himself, right? Again, I repeat that there is a beauty in, or there is a lot of sense in appointing an executor under the will, because the executor can, in his own name, as an executor, do all these things. It is easy. Of course, are the heirs able to do it directly? Let us come to that now. So these are the tasks which are required in administration, and somebody has to do them. So you need somebody who will represent that estate in order to do all this. When we talk of estate, we are talking of the collection of all properties. So somebody has to do this, and that person is the representative. So what we are trying to say is that can these persons who are the heirs, who are the legatees and the executor, okay, can they manage all these properties and distribute them without going to court and asking for a certificate, without intervention of court? Is it there so that they can directly deal with it? So let us suppose I and my brother and my two sisters, we four of us have inherited property. Can we four of us sell away the flat of our ancestor? Can we four of us go to the bank and say, give us the money? And the answer is yes. We do not need any representation from any court. And this is the fundamental principle which I would like to stress. Okay. So as way back as 1799 in Bengal and 1802 in the Bombay, these two provisions, right, they were regulations. They said heirs need not apply to courts for permission to take possession so far as this can be done without violence. So heirs are free to collect properties, to take possession from tenants. And if this is happening without violence, there is no need of a court order. Second, courts also are restricted from interference except upon a complaint. So courts should not intervene unless the word used is a complaint. So somebody takes a grievance to the court and says help. And the third is, in case there is a dispute, then what is the procedure to be followed? That was given in these regulations. I highlight the first point, that the heirs need not apply to courts. So what happens is that while collecting this estate, there are strangers involved. Who are they? They are the debtors, that is those who owe money to this person. So let us suppose that me and my sister, we are the heirs of an ancestor, okay, my mother, let us say. And we both go to the bank and say, give us the money which my mother has kept with you. So the bank will now face these concerns, and these concerns are given here. The bank will say, are Mrs. Bhadhade and her sister the only heirs? What if somebody else comes and claims later? Are they really the heirs of this person? Right? Why? Because who knows that the name, there are common names, and the deceased, there are so many people who are deceased with the same name, and their children will also have same names, right? So who is this deceased? Is this really his property? Are these people really his heirs or not? That is the first question. The second question is, well, what if there is some other heir and they come and claim? If we give money to Mrs. Bhadade, then some other heir comes and claims. That is the risk. So if we go to this bank with a will, then the bank will say, is this really the will of the ancestor, the deceased? Is this really the last will? Is it a valid will? Because if they pay up and it turns out that the will is invalid, then their payment is wrong. Okay. So also there are persons holding property. For example, there is somebody who is holding, let us say, material which is kept as a pledge. And the pledgee wants to return it. So the pledgee will say, what if I give this to Mrs. Bhadade and somebody else comes and claims it? What will I do? And there are record keepers of deceased property. I've used this new word. What is record keeper? The revenue record. The housing area development authorities. What do? They maintain record of people who already hold a title. So they also feel that what if we enter the name of Mrs. Bhadade on the flat and tomorrow somebody else comes and claims? So these are the concerns. So understand what are the risks, okay? So what are these risks they face because of these concerns? Suppose somebody comes up later, they will have to pay again. Okay? Because they are not paid to the right person. And the right person doesn't lose his right simply because he has paid it to somebody else. Then they will face litigation expenses. So pay over again is actually the amount only or the property. But they will have to face litigation and incur that expense. And sometimes they may be required to compensate for loss suffered because of their action. So what do they want? What they want is that they don't want to pay over again, which means they want a discharge. Once we have paid to Mrs. Bhadade, we are no longer liable for that amount. Remember, for that amount, for that deposit, for that property, for that material which is kept as a pledge, we are not liable. We want a discharge. We want to be free from liability. This is what they want. And they also want that if they suffer any loss because they have handed over to Mrs. Bhadade, then they want that the loss should be covered. This is indemnity. So what they want to cover the risk is they don't want to pay over again, so they want a discharge. And they don't want to suffer a loss if somebody makes a claim, so they want an indemnity. Now, these are risks after all. Before proceeding ahead, let me also deal with one more aspect. There is no legal bar to deal with the heirs. So the bank might as well believe me and pay off the money. They are not required by law. Because there are RBI guidelines, but let us say it's a private person. Not required by law. They can simply say, I know you, you are the heir, I will pay you off. No problem. So just as heirs can proceed without representation, even the strangers can proceed without representation. The second is they can take the risk. So there is somebody who says, I will hand over possession. Let me see when the risk comes at that time. Okay. Or banks pay off smaller amounts, mutual funds hand over smaller investments just by taking an indemnity bond and an affidavit. So they don't insist that you go to court and get a certificate. Why? Because they are willing to take that risk for a small amount. Remember, if I am a bank, I will say that for such a small amount, no one will go to court. So I don't see that there will be any chance that I will be required to pay again. So I am able to take that risk. So they may take the risk. Or they will say, we want to cover the risk. So how to cover the risk? Go to the court and get certificates. If the court gives you a certificate, then the law, which is the Indian Succession Act, says that we have a discharge and we have an indemnity, right? So the effect of indemnity and discharge is given under the Indian Succession Act when payment is made to the person holding these certificates. I'm talking of all certificates in general. Now, so the court appoints these representatives. Here we see, they say go and get formal recognition from the courts, right? So the court appoints these representatives. and it grants different kinds of certificates. So what are these certificates? One is probate, which is granted if there is a will and an executor appointed. Then there are letters of administration with a will if there is no executor, and without a will, that is where it is intestate. Then there is a succession certificate which is granted for debts and securities. And there's an heirship certificate under the Bombay Regulation VIII of 1827 and under the Administrators General Act, where the Administrator General has letters of administration in respect of properties. He can give further letters or further certificates to an heir to go and collect those properties. There's a very peculiar situation. Now, when I talk of heirship certificate here, I'm talking about heirship certificate which is granted by courts. In many states, revenue officers grant heirship certificates. And the Supreme Court has said, one is the full bench judgment of the Madras High Court, and the Bombay High Court. Later on, I will give the citations to Mr. Chatrat and he will put them in the description, where I will say that the gist of the judgments is that what these revenue officers give are in the nature of relationship certificates. That this person is the son of so-and-so, this person is the daughter of so-and-so. And they cannot be taken on the same footing as certificates which are granted by courts. So when I talk of heirship certificate here, I'm only talking about heirship certificate granted by a civil court, which happens under the Bombay Regulation VIII of 1827. I am not referring to heirship certificates granted by revenue officers. So now, after a lot of study for 3.5 years and plenty of discussions between us three authors, that is me, Nilima Bhadhade, Advocate Arjun Dalal, who practices in Pune, and Advocate Himanshu Saraswat, who has just started his practice in Delhi. You know, we started from nowhere. There is no book on this subject. The regulation is so old that its language is very different, not like the Succession Act. The terminology used in it is different. And the judgments are only judgments of the Bombay High Court. So we studied all the judgments and we were able to put in all this information so that this book becomes a commentary as well as a manual. It is not a digest, it's a commentary and a manual. The publisher is Hindlaw House. We were very fortunate to have a foreword by Honorable Mr. Justice Abhayok, Judge Supreme Court of India. And he has indeed recommended that this book is a must for people, for judges as well as advocates, and also those strangers, because heirship certificates will be correctly asked for and correctly given. I mentioned in the beginning that very few advocates also know about the procedures. So this book will help them. And this book will be available from 10th of April, 2025. It was released by Justice Abhayok on 15th of March. And it will now be available from 10th of April, 2025. I will not go back to the book anymore. So let us proceed with heirship certificates. So what is this Bombay Regulation VIII of 1827? A very old law, almost 200 years old. The title of this regulation is Administration of Estates Regulation. So it deals with administration of estates. We have seen what is administration. And after it being Bombay and after state reorganization and the Constitution of India saying that old laws will continue, the Bombay regulation therefore now applies to Maharashtra and Gujarat. And very surprisingly, in the province of Sindh in Pakistan, because it was part of Bombay once upon a time, the same regulation applies as the Sindh regulation of 1827. Now it has 2 chapters and we deal only with the first chapter, which is our heirship certificates. And it is called Recognition of Heirs, Executors and Administrators. So the important word is recognize. Who? The heirs or the executors. I will forget administrators for the time being. Heirs and executors. And Bombay regulation starts off with what we saw in the earlier regulation of 1799 and 1802. And I will read only the main section. Whenever a person dies, leaving behind property, whether movable or immovable, the heir or executor, so on, may assume the management or sue for recovery of the property in conformity with law or usage applicable to the disposal of the said property without making any previous application to the court to be formally recognized. This essential principle is put in so many words in this section, and I believe that the Indian Succession Act does not disturb this principle. Despite section 212 and 213, this section does not, this position is not disturbed by the Indian Succession Act. And then it goes on to say, but why heirship certificate then? Why grant it? Then it goes on to say, but if an heir is desirous of having his rights formally recognized by the court, which right? The right of managing and administering the estate. This right, he wants to be formally recognized by the court for the purpose of rendering it more safe for persons in possession of or indebted to the estate to acknowledge and deal with him. So if this heir is desirous that these people who are in possession of the property of the deceased or those who are indebted to the deceased, they will feel safe for that reason and they will acknowledge him and they will deal with him. He wants this to happen. Then he can apply for heirship certificate. See? So the purpose is that those strangers want it. That's why you give me this heirship certificate. If you give it to me, those people will pay me easily. So it is comfortable for me. It is convenient for me. That is why give me the certificate. You will notice that the language is so different. Now, the Indian Succession Act came after the Bombay Regulation. And it so happens because the Bombay Regulation is a very short act made in different language. It doesn't deal with the entire subject. Section 390 of the Indian Succession Act 1925, it specifically states that some sections which apply to succession certificates, they will apply to heirship certificates. For example, what is meant by security? Then your application must set forth the debts and securities, and I say the properties as well. What should be the contents of the certificate? That the grantee should give security, that the certificate can be extended. 377, what is the form of the certificate? 378 is amendment of certificate. 379 is how are court fees to be deposited in court. 381 is effect of the certificate. 383 is revocation. 384 is appeal. 387 is that it does not affect rights, it does not confer title, and it doesn't take away anybody's title. 388 is delegation of jurisdiction. 389 is surrender of certificates. So these provisions equally apply to heirship certificates. Now let me tell you one interesting thing, that the Bombay Regulation is of 1827. However, the Indian Succession Act in section 390 as enacted in 1925 still recognizes heirship certificates. When this came up before the Indian Law Commission for the purposes of amendment, this law, Indian Succession Act, the Indian Law Commission also said that there is no need to disturb with the Bombay Regulation. Then when the Maharashtra Law Commission sat to look at old acts and whether they are to be repealed, the Maharashtra Law Commission also said that this is a very useful regulation and it must be retained. And so it continues. So now, who can apply? It is the heir who applies. So even if there is a will, the legatee can apply if he is an heir. And an heir is one who gets property as an intestate. So if the son is a legatee and the son is also the heir, then the son applies because he is an heir, right? And if there is an executor of a will, the executor can apply. So when they apply, they have to prove the death and they have to prove the relationship. Okay. Then what do they claim in that? They claim that they want possession of the property or they want to recover a debt. That is the original intent of the regulation. Collect debts and possession of property. But over the years, especially the Bombay High Court, because most of the judgments are from the original jurisdiction of the Bombay High Court, it has been granting, and even civil courts, they have been granting heirship certificates so that the person can go to the revenue officer and say, put my name for that land, enter my name on the land. So over time, applications are made, please make me the heir because the revenue officer wants it. Please make me the heir because the flat is to be transferred in the cooperative society. Please declare me or recognize me as heir because I want to collect the documents which are kept with a bank under a mortgage. And the person who kept the mortgage has died. And even for transferring licenses, where licenses can be transferred to heirs. And people have even sought them for the purposes of employment on compassionate grounds. You know, sometimes the employee is dead, then a close relative gets that employment under the service rules. According to us, the three authors, heirship certificates are not meant for this reason. And especially if it's for employment, the certificate is not of heirship because employment can't be inherited. It's actually a relationship certificate. And so we say, the authors say that heirship certificates are not meant for these. But anyway, people ask for them and they are granted. And after a judgment in Group Gram Panchayat, to which I will come to later, Group Gram Panchayat case, applications are made, just recognize us as heirs. We will use the certificate sometime later. You know, that is the tone of that application. So applications are made with that purpose and they are granted. And I believe that this is totally outside the purport of the regulation, but they are done. Where do you file the application? The tenor of the regulation is that you apply where the property is situated. But if you go through all the, when you go through the orders of the Bombay High Court in original jurisdiction, we read almost 1,000 judgments, right? Most of them were heirship certificates granted on consent. So they were one-page orders. Nothing decided in it except to grant. And we noticed that they were also granted where the deceased resided. So the deceased resided in Mumbai, therefore heirship certificate is granted in Mumbai. So the next is, which court do you apply? You apply to the district court. Zilla court is what the Bombay regulation says, and the Zilla court is the district court. And in Bombay, the High Court in its original jurisdiction is the district court for the purpose of this regulation. Or to the delegate. So the state government long ago, by notification under section 388(1), has delegated powers of the district court to lower courts, that is Civil Judge Senior Division and Civil Judge Junior Division in Maharashtra, and Senior Civil Judge and Civil Judge in Gujarat. And based on that, the applications can be filed based on the valuation of property. So we have to go by the pecuniary jurisdiction. When do you file it? You file it 3 years from the date of death, definitely. But usually somebody will think about filing it only when it is demanded. So let us suppose 2 years after death, one heir goes to the cooperative society and says, please transfer the flat to my name. And the society says, go and get a certificate from the court. Then the right to apply will accrue from the date it is asked. And so there is case law to suggest that it can be filed within 3 years from the time the right to apply accrues. For example, when it was demanded. We all know that when you claim more limitation than the first 3 years from death, you will have to explain it in the application. Then what are the court fees? Court fees are paid on 2 stages, like succession certificates and probate in Maharashtra. One is at the time of application, you pay a small fixed amount, which is between 40 to 60, Maharashtra and Gujarat. And if the court grants a certificate, then the certificate, before it is issued, you have to pay court fees. And that is based on the value of the property as on the date of application. The maximum court fees in Maharashtra are 75,000. So it is in Gujarat. And for the purpose of valuation, Along with the application, you have to give a valuation affidavit. Its form is in the Succession Act, which will state the value as on the date of the application. In Maharashtra, there is a notification which reduces the court fee to 10,000 rupees if a widow has applied. This is reduction by notification. Now, what has happened is that over time, applications are made without reference to property. So property is not stated in the application at all. Purpose may be stated, but property is not stated. And in this judgment, which I say, Group Gram Panchayat versus Sunanda Shamrao Bandishti, a very well-known judgment cited later on and followed in so many cases later. The court says that after all, this is only for recognition of heirs. So where is the question of property? And it allowed the party to remove the property from the application, description of property from the application. And later on, later judgments say that court fees need not be paid because no property is described. This is a matter of concern, and I will tell you later why. But the point is that today, based on this judgment, applications for heirship can be made without referring to any property. And I believe this is wrong, and I will tell you later why it is so. So what is the procedure after the application is filed? Application is like succession certificate. You tell that there is a death, that you are related. These are the other relatives, so other relatives are also to be stated, and you say, please give me the heirship certificate. After that, the court issues a proclamation. In today's world, the proclamation is a public notice in the newspaper, and it is to be pasted in a few places in the district. Then notices will be served to other heirs. Sometimes this is called citations. These other heirs may come and give their consent, so there is an affidavit of consent, or they may raise objections. Now, objections in heirship certificates can be raised on only, of course, there are grounds of revocation, but the main ground of annulment under the heirship certificate law is that I am a more preferable heir. So why did you give it to the brother? You should have given it to me because I am the son. I am the preferable heir. And objections can be raised, I believe, on all the grounds on which revocation can be sought. But we have not found a judgment to that effect. Now, if objection raises complicated or difficult question, then this judge should not decide that question. So all the judge says is that this is the complicated question. So parties, you may go to civil court and I will stop the proceedings, suspend it. And when the civil court decides, if it is in favor of the applicant, he can come back again and he can pursue it. Now, remember, if it's a probate or letters of administration, the case becomes contentious and it is decided. So the points of dispute are decided. If it is a succession certificate, the court can still grant a certificate to the best person who is entitled to. But in heirship, if this is complicated, the court refers it, tells the parties, go to the civil court, I will suspend the proceeding. And a typical case is where one person claiming to be the wife has applied for heirship certificate, and another woman comes having equally good material, documentary material, and says, she is not the wife, but I am the wife of the deceased. And the court cannot then decide who is the wife because that requires evidence of a different kind. And if there is no objection, or if the objection is a small one, then the court will grant the certificate to the applicant. The procedure is a summary procedure based on affidavits. Prima facie need not go into details. However, evidence may be recorded. It may be recorded typically where there is a presumption of death issue. Then the court will suspend proceedings if the question is complicated or difficult, or it may grant a certificate or it may refuse a certificate. And there are provisions of appeal in the Indian Succession Act. That provision applies. So there can be appeal from these two. And even if a certificate is granted, the party who is aggrieved can still file a civil suit in the court. And if the certificate is refused, then the applicant whose certificate is refused can still file a civil case in the court, or they may go in appeal. So they have actually double remedy available. Now this certificate will give the name of the representative, and that he is recognized as the heir of so-and-so deceased, and it will give the list of properties with details and value. Now, there is an importance in this. That importance is that unless a particular deposit is mentioned in the heirship certificate, the bank or the company with which it is kept should not be handing it over to the grantee. They should see that the property is described and then only they should act on it. And therefore, it is important that the list is there. And therefore, I mentioned that applications which are made without reference to property, they are not correctly. It is not correct to do so. So now this is an important part. What is the effect of the certificate? Like probate, letters of administration, and succession certificate, heirship certificate also is conclusive as to the representative character of the grantee. This is now, of course, because of a section in the Indian Succession Act. But even before that, long ago, judgments recognized this. What does this mean? If you are owing money to the deceased, and if I am the grantee, I have got the certificate, and I come to you, you have to recognize me as a certificate, as the representative. You cannot say, Mrs. Bhadhade, you are not the representative. Your sister over there, she is the correct person. You are not entitled to say that. You can only recognize me as the representative and nobody else. So as against you, as against a debtor, as against a person in possession, they have to recognize the representative. But when I come to you with a certificate and you are the company, you need not pay the amount to me. You can't deny my representation, but you needn't pay me. Why? Because you may have a right of set-off, you may have other rights of lien, etc. You have another claim against the deceased, which was in the nature of a counterclaim or a set-off. So you can say, no, I will not pay. You may be the representative. Remember, even if the deceased person were existing, even if he were alive, this person would not have paid the amount. So why should he pay to the representative? He has the same defenses, isn't it? So he can simply say, I will not pay. And if he has a valid defense, very good. If he doesn't have a valid defense, the liability to pay interest starts. Second, so I said it does not bind the debtor. It does not confer title on the grantee. So if I have a heirship certificate, that doesn't mean that I own the property, nor does the certificate give me the property. Remember, the next is does not guarantee the deceased title. Let us suppose that in my application I have mentioned that plot number 15 was owned by the deceased so-and-so, right? And the certificate mentions that plot. That doesn't mean that the deceased owned it, because if he owned it, he had title. Maybe he didn't own it. So the certificate does not change the title position at all. And please remember, this is true of every certificate, even probate, letters of administration, and succession certificates. So these 4 points apply equally to all certificates. Now, if the payment is not made, I'm on second point, it does not bind the debtor. The debtor doesn't make the payment. Then what should the person do? Grantee do? Well, he must file a suit. And this is again true of all the certificates, all the 4 certificates, even those granted under the Indian Succession Act. So probate may be valid and conclusive that this is the final will. But if you take a probate to somebody and say, make me the payment, that person can say, I will not pay you. Maybe the will is valid, maybe you are the executor, but the certificate is not an order against the stranger. Remember that stranger debtor is not a party to this proceeding. So it is not an order against him and it does not bind him. This is something we remember. Now, why is it that the property should be mentioned? And earlier I mentioned to you that these strangers require discharge and indemnity. So 381 of the Indian Succession Act, which applies to heirship certificates, as I mentioned, it says that the certificate shall afford full indemnity to all such persons as regards all payments made or dealings had in good faith in respect of such debts or securities to or with the person to whom the certificate is granted, right? Full indemnity. Full indemnity means the amount also and the expenses also. All that he is entitled to get in respect of payments which he has made. Such debts and securities. Which are such debts and securities? The earlier part of the section says where a certificate is granted for the debts or securities which are stated in the certificate, then for such debts and securities, there is indemnity, provided the amount is paid in good faith, right? So if I take the certificate and bring it to you, you are entitled to inquire whether I am really the heir of that person, whether that person owing the amount lying with you, it really is owned by the deceased, or is it somebody else having the same name? So it's not that you should directly pay it to me simply because I asked. You're required to pay in good faith. Okay. So when it's paid in good faith, and when the debts and securities and the properties, because this section applies to succession certificate, heirship applies also to properties. So when the property, debt or security is stated, then only there is an indemnity. And that is why applications must be made with reference to properties and debts, and the certificate should be mentioning them. And that, I think, is the correct way of applying for and obtaining heirship certificates. Now, the main question is why heirship certificate? Why not succession certificate? Why not probate? Why not letters of administration? There's one point which I missed, which I should add. Let me add that, please, because it's a very important point.
Yes, ma'am.
Yes. I'm just making this change.
Okay.
Yeah. Is this visible now? So, firstly, heirship certificate, unlike succession certificate, remember, a succession certificate and heirship certificate, even if there is an objection, the procedure is summary. Heirship certificate can be asked even for movable or immovable property, including debts and securities. And it can be applied for and granted even where immovable property is situated in Bombay, because I won't say Calcutta and Madras because the regulation doesn't apply there, or even where letters of administration are compulsory, where the property is situated there or the deceased resided there. So instead of asking for a probate, you can simply ask for heirship certificate. Then it can be asked for and granted even if there is a will or not, and even if executor is appointed or not. If executor is appointed, executor should be asking for it. And if there is a will, the legatee can ask only if he is an heir, but otherwise it is given only to an heir. Then it can be asked for any or all properties of the deceased. If it's a probate, then the executor has to list all the properties. But an heirship certificate can be asked only for one or two or three of those properties where representation is required. Then it is granted to the applicant, but sometimes it has also been granted to the non-applicant. You know, there is an objection, but finally the objector says, okay, granted to both of us. So cases indicate that it can be granted even if there's an objection. Consent can be given and it can be granted to both. Now, this certificate gives formal recognition as heir, that is its purpose, and the proceedings are summary, so they happen faster than probate or letters of administration, because in case of dispute, probate and letters of administration proceedings proceed like a suit. And therefore, heirship certificates, especially when they are to be obtained with the consent of the other heirs, there will be no dispute. It is a very good proposition to ask for heirship certificates rather than for the others. But frankly, probate and letters of administration are the best certificates because they are conclusive as to the title of the executor and the administrator, and conclusive if there is a will as to the finality and validity of the will. So they are the highest in form, but heirship is easier to obtain. So I come back again to this book. This book is like a manual. It gives forms of affidavits, certificates, applications, what should an application contain, and so on. And it is a commentary. Justice Oak also observed during his keynote address he gave at the seminar where he released the book. He said that this book is a commentary and not just a digest. And the last chapter, what we have done is we have written 10 chapters which are for use for those who want to apply for or act upon or give a judgment like judges on heirship certificate. And whatever are our concerns, why is it given without property? These kinds of concerns we have listed in the last chapter, which is a critical commentary. This book also gives all the statutes which are required for heirship certificates, like court fees, limitation, Civil Courts Act, the Civil Manual, the original side Bombay High Court Manual, and so on. And it also gives about 15 judgments, which are case law, which are cited again and again. The full text of the judgment is given in the book. So if you want to know or apply for or give a judgment about heirship certificates, then this book contains everything. I will request you to obtain the book in case your practice is going to involve applying for heirship certificates in Maharashtra or Gujarat. Thank you very much. And if there are any questions, I would love to answer them.
Yes, ma'am. One is in the chat box itself.
Okay. Shall I think yes, I will minimize. No, let me open the chat box. Let me see. Shall I close the presentation?
Yes, ma'am. Yes.
Let me just check how to do it. Yes. Oh, even without closing, I can see the question. That's good. Yeah. I have a doubt with respect to property. In case if a building going to redevelopment, the flat owner dies and he has not left any will and MADA is asking for heirship or an LOA. If the heirs apply for either an LOA or an heirship, and in the meanwhile the building goes for redevelopment, then how to add new address in the future to LOA heirship certificate list of properties if it is granted prior to completion of the new building? What I can see here is that the property is the same, that is a flat in that location, but the description of the flat may be required to be added. So changes in the, okay, this requires a correction in the heirship certificate, and there is a provision for correction in the certificate. It comes from case law under the succession certificate related provisions, where they say that where corrections are to be made, they can be made. If it is an extension, that is something more than what was asked for is asked in it, then that also can be, you apply for and get it added to the heirship certificate. But frankly, much depends upon how that property is described in the heirship certificate already granted. Just a minute, let me see the question again. How to add new address in the certificate list of properties. So that you do by applying for an extension or by applying for a correction. And there is a judgment which says that the court can do that if at all not under any other provision, then under its inherent powers. I believe that an application of extension will be required. Provisions of extension of certificate, which are, I believe, in 388 or 389. Let me just bring that slide in front of you. Extension is here, 376. Is that visible? Yes, it is 376 of the Succession Act, which talks about extension of certificates. Could you hear my whole answer, Vikasji? Yeah, good. Thank you.
Question on the YouTube. One is that
yes.
if old lying in a locker of a deceased mother, whether a civil suit lies or an application under the Indian Succession Act?
If it is for the purposes of opening a locker, then succession certificate cannot be obtained. Heirship certificate application can be filed. Its valuation will have to be given later. So the first order will be to open the locker and open the contents. I believe that an heirship certificate application should give the answer. Otherwise, letters of administration or probate.
The second question is?
Yes, there is a question. Just a minute. Application under the Indian Succession Act is not maintainable, compelling heirs to withdraw it and to file a suit for mandatory injunction. What is the correct remedy? Suits are meant for asserting and deciding rights, and proceedings under the Indian Succession Act are for getting representation. I mentioned to you, representation is about exercising powers, and title of a person is the right. So if I want to say that I am the owner of the property, then I have to file a suit. If I want to evict somebody, I have to file a suit. If I want to collect money of debt, amount of debt from the debtor, I have to file a suit. What I get is a representation under the Indian Succession Act. So if I get a succession certificate, I go to this debtor and say, please give me the money I represent. And when I say that, the person can say, no, I won't give you. But if I file a suit against that person, then naturally he has to pay because it becomes a decree against him. There is one point which I forgot to mention, that section 214, which says that a decree cannot be passed and it cannot be enforced against the debtor unless there is one of these certificates. So even the heirship certificate can be applied for, and then the decree can be executed. Advocate Sadaf Sheikh asks, in case of joint ownership, one owner passes away. So now if the other owner wants to sell the property, in such case also heirship certificate will be required. First of all, for sale of property, if the purchaser is willing, he can simply buy it straight away, right? Who will be selling it? The other joint owner who is alive and the heirs of the joint owner who is dead. Now, if the purchaser is willing to accept and take the risk, he may buy it and he takes the risk. And he might buy and say, okay, you give me an assurance, you give me a warranty, and you give me an indemnity that if somebody makes a claim, you will make it good and I will buy it. So no certificate is required. Now, a purchaser might ask for an heirship certificate because he wants to be in the clear. If I were a purchaser, I won't ask for an heirship certificate because heirship certificate does not do anything. I will say you get letters of administration. So you see, everything depends on how the purchaser perceives it. Will an heirship certificate be required? So if the purchaser says get an heirship certificate, then the heirs of the deceased joint owner will have to apply for it. It may be the other joint owner or it may be some other heir. So I hope that question is answered. And Sadaf Sheikh continues, and is that heir certificate can also be used in other states to dispose property there? Now, this is a very fine question because it raises more issues. When the Bombay Regulation Act came, it was contemplated that for every property in any different districts in Bombay, naturally. So for, if it is Pune district, you go to Pune court and apply for heirship for the property in Pune district. And if it is Satara district, you go to Satara district and apply for Zilla court over there and apply for it. This was also a judgment, a very old judgment of the Bombay High Court. Now, no one has noticed those judgments. And we have heirship certificates which are recognized throughout Maharashtra. If you go by the principles of private international law, what is private international law? That law which would apply if a number of laws become applicable. So property is situated in Uttar Pradesh, but the person ordinarily resides in Maharashtra. Can he get an heirship certificate? Well, heirship certificates have been granted by the Bombay High Court for properties even abroad. Somebody was employed abroad, he died, his employment dues are to be collected. So the courts here have granted heirship certificates. Should they be granting it? I say no, but they grant. Now, if the person abroad is willing to accept it, he is willing to take that risk, so be it. Can an heirship certificate, should it be asked for properties outside Maharashtra? Well, it depends upon whether the person there is going to recognize the heirship certificate. If he will recognize, very good.
Yes.
I hope that answers it.
Yes.
Any other question?
Nothing. I will just ask, like normally we have started doing, if we can summarize for a 5 minutes or a 10 minutes capsule, what is the pith and substance of the entire session?
I should summarize.
Yes, ma'am.
Very good. Heirship certificates are certificates granted to a legal heir of a deceased person so that he can represent the estate. It does not give him ownership or title of the estate because he already has it as an heir. It is granted under Bombay Regulation VIII of 1827, and this law currently applies to Maharashtra and Gujarat. A person who is an heir or an executor of a will, he makes an application for heirship certificate. He will give a list of all those who are the other heirs. A proclamation is issued. If no objection is received, the judge will just ensure that this person is an heir and grant him a certificate. If objection is received, the judge will see what is the issue. And if this issue is complicated or difficult, he will simply suspend the proceedings and tell the parties go to the civil court. Finally, after a summary procedure, the heirship certificate is granted. The effect of heirship certificate is that it gives a discharge and indemnity to persons who will hand over properties or the debts to this grantee. They are discharged and they get an indemnity. And a clear provision of indemnity is found in Section 381 of the Indian Succession Act. By the way, please read Section 390 of the Indian Succession Act and the sections of the Indian Succession Act which are also applied to heirship certificates. Now, this certificate is conclusive as to the representative's claim to represent, power to represent, but they do not bind the debtor or the stranger or this third person in possession. If he hands over the property, he is discharged. But the heirship certificate, or for that matter, probate, letters of administration, or succession certificate, they are not an order against that person, right? So they can refuse. They may have a valid claim under which they refuse. Now, heirship certificates are better than others because the procedure is a summary procedure. They can be asked for in Mumbai, even if the immovable property is situated in Mumbai. And they are granted for all kinds of properties. And of course, I told you about the book, which is written by me, Advocate Arjun Dalal, Advocate Himanshu Saraswat, and published by Hindi Law House. Thank you very much. It was wonderful to talk about this.
Same here,
to summarize all that goes into the 400 pages book.
That's true. I believe that whoever wants to learn would definitely have learned today, and the book will actually add knowledge to it. Thank you, everyone. Stay safe, stay blessed. And it is always knowledgeful to learn from ma'am. Thank you.
Thank you very much. Can I leave?
Yes, ma'am. Thank you.
Yes.